Very thrilled to be in Moscow once again. I say Moscow because I'm not from here. I don't know what the Moscow thing is. I'm from Appalachia, so we pronounce most things wrong. You want this down?
Yeah.
Well, this is Jared Height, so I thought we just did. Okay. The title of the lectures, all four of them, has already been revealed and announced. There's obviously the allusion is to Matthew, and the theme, the appropriateness of the theme will become clear as we go on. But the title of this first lecture is called Never Let a Good Crisis Go to Waste. That maxim is often falsely attributed to Winston Churchill. It definitely sounds like something he would say. There's no evidence of it. It's in fact Rahm's rule, Rahm Emanuel's rule, not quite Churchill caliber in my opinion, maybe the Churchill of the Obama administration, I'm not sure, who supposedly uttered it during the financial crisis. And the point is that in the midst of crisis, a new range of previously unavailable or unthinkable possibilities emerge, and it's in the crucible of chaos that they become acceptable and applicable. So I think it's a good phrase. I think it's a good maxim, actually. Like anything, it can be abused, and it certainly was by the one who first uttered it. But we're going to use it today. What we're going to do in this first lecture, and the four doesn't mean they'll be coherent, but they do cohere, so you have to come to all four to understand what's going on. The first lecture is going to be predominantly what you would do in the first year of law school, which is learn how to issue spot. Maybe that's all you do in law school. You don't actually memorize anything. You don't actually really learn all that much law. You learn how to spot patterns. You learn how to see issues, and so that later you can pretend like you know what you're doing once you graduate and pass the bar and actually have to learn something. I submit to you today that in the law, we are entering, or more likely have already entered and been living in for a while, a crisis that is greater than anything predatory subprime lending wrought. Perhaps not to our pocketbooks, although that remains to be seen. It may well hit there as well, but certainly in the soul of our nation and the coherence of law as a discipline. I want to briefly describe the crisis as I see it to you today, as well as the new range of possibilities spawned by it, although the latter will be the focus in more depth of later lectures. Only the words on the page constitute the law. With that line correctly attributed to Justice Gorsuch, not Rahm Emanuel, although he could have said that too. Gorsuch being ostensibly a textualist and originalist. In that line, he was writing for the majority in the recent Bostock opinion, and it signaled two things. First, it signaled, at least for some, the end of what had been known for the past several decades as the conservative legal movement or legal project. In a memorable speech, Senator Josh Hawley, Republican Missouri, pronounced the movement dead at the scene for the simple reason that, quote, if textualism and originalism give you this decision, if you can invoke textualism and originalism in order to reach such a decision, then textualism and originalism and all of those phrases don't mean much at all. I think he was correct. Bostock, of course, read projections for all manner of newly minted sexual deviant identities, quote unquote, into Title VII of the 1964 Civil Rights Act. That is, under the pretense of divining the original public meaning, supposedly, of the statute, the Supreme Court determined that cross-dressing men with a penchant for self-mutilation and public eroticism would have been cognizable as a protected class in employment law to the American legislature and the general public in the 1960s. A fantastical conclusion, I think, needless to say, and is reflected in the text exactly nowhere. No matter, the revolution will be administered until morale improves. Senator Hawley was right to castigate the Bostock majority and was astute in pointing out the ineffectiveness of the conservative legal movement as it's been known, understood, and practiced. That movement being predominantly a reaction to post-war Warren Court excesses that but it failed to actually produce any major victories for conservatives, very few. Originalism is a sort of first-in-time positivism, we'll return to the meaning of that later, did little more than slow the progression, certainly was not capable of producing a 180. Originalism is an approach to the Constitution. Textualism, its companion, is a statutory interpretive method, constitute, I think, what Patrick Deneen has called defensive crouch conservatism. They are, in effect, limiting principles of jurisprudence meant to mitigate gains from the opposition, not meant to produce anything positive or prescriptive in themselves. Perhaps there was a time for that. We don't always get to choose the battlefield. Sometimes you get caught on your heels. But prudential concessions to an unfavorable scenario cannot become the rule, or rather, as it has been for many conservative jurists, infallible writ. Defenders of originalism and textualism, upon receipt of Gorsuch's gift, retorted that Bostock was not a fault of originalism or textualism as such, but only an example of its abuse. Those of Hawley's persuasion more or less rolled their eyes at the textualist apology. The proof is in the pudding, they said. At some point, the communist insistence that the real communism hasn't been properly tried gets a bit tiresome. Everyone agreed that the court had, yet again, put on an exhibition in rhetorical and textual gymnastics, this time, though, delivered by one of our own. Whether originalism or textualism would continue to provide, or ever had provided, a stopgap against such maneuvers, there was a deeper revelation exposed, if not created, by Bostock. This is the second issue we need to draw our attention to. That case, meaning Bostock, as well as Obergefell and all of its ancestors before it, signaled what was not simply the failure of the conservative legal movement to produce wins, but the morally anemic, hollow nature of the same movement and its preferred jurisprudential methods. It was rather poetic and appropriate, I think, in a morbid way, that Bostock was written by a Protestant. Perhaps not a very good one. Gorsuch is a sort of half-baked Episcopalian with papist leanings, and as Tucker Carlson recently put it, Episcopalianism's barely a religion at all. But he is a Protestant, nevertheless. I say it's appropriate that a Protestant drafted this opinion and got the votes for it, because America has been, and still is, statistically, a Protestant country. 98% Anglo-Protestant at the founding, something we'll talk more about in future lectures. Yet Protestants, since the fall of the WASP mainline establishment in the mid-20th century, if not there before, have abdicated socio-political leadership. The only Protestant on the bench is a Catholic-leaning Episcopalian, as I said. There are far more Catholics and Jews that dominate the court in recent memory. And this particular Protestant seems to think that a statute passed in the 1964 forces employers to tolerate cross-dressing in the workplace, and further thinks that a rather minuscule percentage of the population is worth taking a blowtorch to the entire metaphysical moral basis of Anglo-American law. Not exactly a good showing for Protestants, I would say. Whether because of their hereditary neuroticism, as Michael Knox Burnham would have it, or their inflexibility to newcomers, as Digby Baltzell would conclude, or a general diminished confidence due to the series of national setbacks in the post-war period, the WASP mainline class experienced a slow, then very fast, decline in the 20th century. The country's leadership transitioned away from Protestant dominance, and as I said, other faith groups, however sincere, took the reins. Evangelicals, being a more folksy sort of voting bloc in the Bible Belt, certainly didn't seize the opportunity. What is fascinating, not necessarily causal, but at least conspicuous, is that in the midst of the decline of Protestant leadership generally in the 20th century, the metaphysical and moral priors of both law and theology also shifted away from the classical commitments held by Protestants of the 300 years prior and toward those of post-industrial modernity, Darwinism, materialism, scientism, in a very literal sense that we'll return to. So-called legal positivism or legal realism shunned the allegedly mystical presuppositions of classical lawyers in favor of shoring up law as a hard science, predictable, formulaic, and policy-oriented, a discipline fit for social engineering according to modern assumptions, free from what Oliver Wendell Holmes called the brooding omnipresence in the sky. Most of all, for our purposes, the law was sanitized of any ontological or teleological consciousness. That is, natural law, participation in divine law, true reason undergirding rules of action in human positive law. Curiously, at the same time, as I already alluded to, Protestant theologians increasingly distance themselves from the natural law tradition. The tradition that the Protestants inherited as much as Catholics and has only recently been begun to be recovered by good historians. But for the 20th century, despite the protestations of a few, most Protestant theologians followed Karl Barth against Brunner in Yelling 9 against natural law's inclusion in the discipline of theology. Again, despite the mass of textual tradition weighing against them. And you see this even in evangelical theology up until very recently, or it's perhaps still persistent. Certain cadres of evangelical theologians outright deny the legitimacy or the utility of natural law for a coherent theology, much less moral philosophy. Of course, just because law was freed from one deity, one theology, does not mean that it became neutral. I mentioned already certain theologians who deny the usefulness of classical natural law. But Cornelius Van Til did get one thing right: there's no neutrality. That's the only thing he got right. I went to Westminster, so I can say that. I did the reading, don't. Some theology, some metaphysic, must provide the answers to the sweet mysteries of life, to invoke not exactly Justice Kennedy, but Justice Scalia's rendition of Justice Kennedy. As Brian McCall put it, and I have to cite a Catholic again because there's no Protestants to cite here, put it in his Magisterial Architecture of Law, reflecting on modern jurisprudence, quote, "If law is merely an artificial fabrication of men, then it can become whatever men want it to be." And I think we've seen as much. Nature dictated by law rather than law by nature. God confined by law rather than law confined by God, and so on. The results speak for themselves as well. Eugenics, old and new, devolution of marriage into a cold, gender-neutral at-will contract, subject to the dissolution when the fancies and aggregate gain of the parties demand it. Prayer and scripture banned from the public pedagogy, parental rights dependent on affirmation of juvenile sexual delusions, and so on. Rights are increasingly conjured up out of thin air through the ever-expanding mechanism of the 14th Amendment, the catch-all for whatever progress, liberation, and libertinism demand. What we occupy is a pure voluntarist positivist legal ethic. By nature, it serves the ever-shifting whims of the atomized individual. And again, Protestants have done little, if anything, to stifle this progression. We certainly don't get justices on the court. We certainly don't assert ourselves with confidence in the realm of legal philosophy or moral philosophy generally. Aaron Wren had recently put out a poll on Twitter not too long ago of who is the predominant or most famous Protestant intellectual. And the results were pretty abysmal. There's nobody, basically. You'll all have your favorite, but they're not as big as Protestants used to be, of course, in our history. Originalism, for its part, acted as a sort of, as I said, first-in-time positivism to slow down progress, but inherently lacked the mechanisms to halt it. And even that was developed by Catholics. What I mean by first-in-time positivism is that instead of asserting what we might say is the way the classical legal tradition used to think, as even embodied by our founding fathers or framers, originalism asserted that basically history began in 1776. And those texts are definitive and must be followed to the letter. And our interpretive apparatus for those, textual interpretive apparatus, is severely limited. Basically, you get dictionaries in the Federalist Papers to tell you everything you need to know. Problem is, neither of those are philosophical treatises, however much Justice Scalia dressed them up and made them seem as so. So originalism was ultimately going to be proven incapable of even doing the slowing, much less the halting. And we saw that definitively in Bostock. And I think even the stubborn few who insist on defending the legacy of these interpretive approaches know in the back of their mind that their time is limited in its use, and certainly with younger lawyers and judges noticing the same. Returning to Protestants, though, in a word, we've sold our status birthright as well as our intellectual birthright in this country. For the 17th, 18th, and most of the 19th centuries in this country, the Bostock holding would not only have been unthinkable, but unintelligible, which it is, or at least it should be, but even we can understand its reasoning given certain priors. As Carl Trueman remarked in his now famous Rise and Triumph of the Modern Self, the idea that a man could be stuck in a woman's body or vice versa is a claim that his grandfather would have had no categories with which to even begin to approach it, but here we are. In any case, as I've alluded to, it was not always so. We've spotted the issue, we've spotted a bit of the crisis. We will continue to expound upon that crisis as we go. To originalism's credit, the filial piety hints in the right direction. The founding and antebellum period, the generations of those period, were classical in their thought, at least on this front. James Kent, famous jurist and philosopher, railed against the mechanical jurist of his day who had discarded moral philosophy, true philosophy, as a prerequisite for establishing rules for human action. Modern psychological man was not in view for him, but rather man is created body and soul, and he said as much. The same goes for Joseph Story. The same goes for James Wilson, who acknowledged that only an intelligent creature who embodied the joining of material and immaterial worlds, sociable, religious in his nature, was fit for law at all. For as Francisco Suarez, another Catholic, you can't get away from them, it's very difficult. Another Catholic of the 17th century noted that when we speak of laws of nature, and we talk about things like gravity and whatnot, this is only a law metaphorically speaking, because law properly requires an intelligent mind, and it's even only metaphorically sensible to call those things laws because an intelligent mind is at least behind them, even if it's not engaging intelligent minds. On and on we could go, stacking up examples from the founding, and we will do so. We could look at the documents as well. The Declaration of Independence, I'm sure you all have read it, hopefully have it memorized, and that should be all you read from Jefferson, ever. It should be read as a philosophical treatise in a way. And where does it begin? It begins with the grounding of the legal basis, the legal case it's going to make, which really crops up in the grievances, right? The grievances against the crown, or really against Parliament, are where the meat is. But it begins with the grounding in nature and nature's God, right? And there's only, whatever the secular atheist historians want to plead, there's only one meaning for that at the time, even for an ostensible deist, who was a really bad deist if he believed providence would intervene in human events. So this grounding was there before, the recognition that law is a subaltern discipline, meaning that it has to receive certain data from outside of itself. It itself is not moral philosophy, it itself is not theology, but it requires both. And one will always be supplied, as I've said. So we do operate with one today. We operate with one that gets you things like Bostock. Justice Alito, perhaps, was the only one who understood appropriately at the time where Gorsuch had gotten his data. And he cites this in his dissent in Bostock and notes that certain amicus briefs that had been submitted by gay activist groups and others had supplied all of the necessary moral data that Gorsuch required to reach his conclusion on behalf of the majority, including the idea that, of course, gender and sexuality and sexual orientation could not be easily bifurcated. Therefore, to discriminate against one is to discriminate against the other, and so on. So for now, we need to return to where we began with our issue spotting, not letting our current crisis go to waste. Here we have an opportunity to return to an older form of jurisprudence, one that recognizes the true nature of man and thereby the true nature and purpose of law. That must begin with the hierarchy of law and its fourfold division, originally drawn from Plato but adjusted, as theologians noted, for their own purposes. Pagans are useful, but not ultimately useful. And so we arrive at the division of eternal, natural, divine, and human law. We have to begin with this division in order to make law intelligible. It's very standard, very classical definition, of course, most naturally found in Aquinas. Eternal law being of course, the basis for all other law, the divine being himself, Natural law being the creaturely participation in the eternal law, divine law being its inscripturation, its republication, essentially in the Decalogue. And then, of course, human law, which is also can be called positive law, law made by humans that must have as its referent some kind of higher law in order to establish its own justice. And in order to refer to that higher law, it must refer to the nature of the things that it rules over. So the nature of man is not irrelevant to the way we rule him. In fact, it's paramount. So if you do not have the nature of man established, then your laws that rule over him will be unjust and ultimately to his detriment. Human law, of course, is malleable. It is established by the one who has care of the community, promulgated by him for the good of the community, not for licentiousness or private interest, but for man's temporal and eternal ends. It must, of course, recognize both of those ends because man is what he is. He's body and soul. And unless you're just governing hogs, like Richard Hooker put it, then you have to take notice, even as the civil or temporal power that is promulgating laws, of what man is. He must be led to virtue, if gradually, which is what law is supposed to do. It's not to free him from his natural boundaries. It's not to free him from a higher law, not to free him from duty. It's not to free him even from the metaphorical laws of nature that we mentioned already. It's in fact to make him conform to those for his good and even for his eternal destiny, which is found only in God. Indeed, ultimately, it has to be directed to this highest good, for the power to establish laws comes not only from the natural law, which stands above it, but the eternal law itself, found only in God's very being. And the power is given directly to the magistrate, who we will return to frequently in future lectures, to rule over men for their good and ultimately for God's glory. So it cannot be ignorant of these things, the nature of man, man's ultimate end. Of course, our modern jurists want to deny this, including the originalists are very reticent to ever inject any sort of moral external claims into the text. Rather, the text is developed by the sovereignty of legislatures, of the people, as they see fit. This is ultimately an extremely popular sovereign sort of approach to jurisprudence, and expects man to govern himself in a way that self-governance was never understood as a sort of expression of localism. And so it's no surprise that we arrive today with man not only choosing to govern himself, but to govern his very nature and to govern those around him. You notice that these supposed live and let live approach, a sort of libertarian-esque approach that most Americans, I think, instinctively have adopted, insist on massive conformity. You have to affirm these things. Why? Because the magisterium says so. Why? Because there's a theology in the background that is telling you what the highest good is and what ultimate freedom and enjoyment of life looks like. It's certainly not coming from the Westminster Catechism, although in the founding period it basically did. So we have our crisis established, and we have what I've already plugged as an opportunity to return to an older form of jurisprudence. Some legal scholars have already tried their hand at this. Once again, a Catholic and a Jew are the two that I know. No Protestants doing it. So you have Adrian Vermeule, who's sort of put forward what he calls common good constitutionalism. It's just classical theory. And you have Josh Hammer, who's put forward common good originalism, another attempt to rehabilitate originalism. I've made my critiques of that, and we don't have to revisit them. But the emphasis that even Catholics, again, are beating us to the punch on a classical approach to morality, to law, is the only possible way out of the conundrum we are in, where we have no jurisprudential approach to stifle any more of the progress. Originalism has failed in that. And we have none to give us a prescriptive, positive vision for what society is supposed to be and what law is supposed to do for society. So what we will be doing in the rest of the lectures is investigating certain tenets and certain aspects of what a classical approach to law would be. This will include, as I already noted, investigating society's relationship and law's relationship to that highest and ultimate good, which requires an establishment of a certain theological position, certain priors, and one that was expressed throughout the country in our earliest documents at the beginning and for some quite time thereafter. And that, of course, is Christianity. We could call it general Christianity, as Joseph Story often did. But the fact of the matter is that it was predominantly Protestant, and even explicitly so. So you could not be in South Carolina or Massachusetts or New Hampshire or even New Jersey at the time and expect to wield any kind of political power unless you affirmed these priors and embodied them in your own life in a virtuous way. This is inevitable. Many will froth at it because they've been trained to froth at it. But we have the same sort of establishment today. As I said, there is no neutrality. The brilliance of the current establishment is it's convinced everybody it doesn't exist. That's really clever. And so part of the first step you must make is to recognize its existence and recognize the power it has over you. Otherwise, you cannot strategize about how to overtake it. And I think the majority of the conservative legal movement still insists that the nirvana awaits us where we can have some sort of grammarian statute-reading judges that exercise no discretion, no determination of law, and are ultimately morally neutral. The sooner we disabuse ourselves of that notion, the better. So we'll be, again, discovering these aspects in coming lectures, and I look forward to getting comments, feedback, questions, and discussion in this community at New St. Andrews that I'm thrilled to be a part of. Thank you.
Timon and I know each other. We've talked about these things a little bit. Podcasts, publicly, that kind of thing. So this might take on a little bit of that podcast nature. Let's, and we're also going to open it up to you shortly. So we have 17 minutes. Don't let a crisis go to waste. The crisis is Clown World.
Clown World, sure.
Clown World's
trash
here.
World, Clown World.
We need to seize on Clown World and not go back to originalism. Go back to classical form of law.
Yeah.
Is that right?
I like to say our guiding principle, because as I noted, I do think love of our founders is appropriate, but let's think like they did, not what they did.
Okay, think like
So
they did.
if they were transported to our current situation, assuming their heads, like the Raiders of the Lost Ark at the end, it didn't happen, their heads didn't explode. Assuming that they survived the initial impact, what would they do? Right, and so because of the prudential nature of law and its need to accommodate circumstance, you can't easily transport it to every given scenario without any change. And I think that fundamentally originalism attempts to do that too often.
Okay, very good. That's very interesting to me. Okay. In Bostock is one example. Obergefell would be another example of two horrendous decisions, right? And you're saying originalism wouldn't protect us from that. And I'd like to maybe deal with Bostock first. So Gorsuch finds that sex can also mean, surprise, surprise, voila, it can mean sexual orientation. Now, I'm just playing devil's advocate, so I'm doing the pure original thing. That's not what they meant.
Right.
So Gorsuch, you can't say that.
Right.
That's not what they meant. Gorsuch, you can't say that.
Right.
And if you say that, Gorsuch, we're getting you out of here. Well, I guess we can't get them out of here, can we? Well, we can through elections. But we're getting you out because that's not what it said. Okay, why wouldn't that kind of just a pure originalist approach be enough?
Right. Well, and in some ways, as I did try to give them credit, it has stifled the progression, but it's only a limiting principle. It's incapable of asserting something positive in the reverse. So if you want to actually reform the country rather than just slow down the progress, it doesn't offer you the tools you would need to do that. It doesn't allow you to assert aggressively the necessary moral underpinnings of law. It simply requires you to parse the statutes, right? It doesn't allow you to, at least at some level, to make determinations of law's application in a just way according to true equity, not whatever people use it to mean today. It hamstrings judges, is my opinion, where they're incapable of performing the function in society they're supposed to.
So in one sense, we just need to be able to tell Gorsuch the reason why it's not in the text, too. It's not in the text, and let me tell you the reason why. From this classical form, that classical form would inform it. And you did eternal, natural,
divine, human.
Divine, and human.
Yeah.
Eternal, the being of God, natural,
Yeah.
man's participation, divine, revealed, human, instantiated law. Is that, in essence, the classical form you're talking about, or would you put any more meat on the bone?
Well, yeah, I would just say the reason you can't do that. So here, here's what we should say about it. There's the famous Kagan point that we're all originalists now, right? The left is they're very adaptable. They're much smarter than we are in this regard because they're brutal and lethal. They figured out how to play the game as well, right? So all of us can kind of play this statute parsing game and figure out how to squeeze in whatever you want, which is what, rightly so, originalists have been accused of doing before, and they do it. So even the idea of originalism and textualism, as it's in sort of the textbook, is a facade anyway. One of the best opinions on this is the Van Orden opinion, one of the Ten Commandments opinions, and Justice John Paul Stevens in his dissent, so he's losing, is referring to Rehnquist and the majority, originalist majority, who have justified the maintenance of the Ten Commandments outside of a courthouse on the basis of sort of Abrahamic religion and Judeo-Christian values, right? And that's their originalist position. And Justice John Paul Stevens, of course, is scandalized by the entire thing, but his history is better than theirs. And he musters a mass of sources that are very good and says, I don't know what this Judeo-Christian values thing is. I don't know what the Abrahamic religion thing is. It's not in the founding. They were Protestants. That's it. So if you're going to justify it, you need to say, we're a Protestant country, this is what we do. But they're unwilling to do that because they know they can't get the votes and it won't sell, right? So it's not a purely textualist, historical sort of analysis. The left would say, or the progressivist judges would say, you're playing the same game and we can play it as well, which is what's happened. So when you come to Gorsuch and you say, he's asking, why can't, if sex has always meant it can't be detached from identity and gender identity, sexual orientation, these things, then that's just what it's always meant, right? So that's what the word means. So again, you're bound to the nature of the thing. So the reason you would tell Gorsuch that he's wrong is because you would have to assert a particular anthropology, sexual anthropology, to say this is simply not the article that you're dealing with. Therefore, it can't mean that because it's not real. But that is going to be difficult to convince strict originalists and textualists to do.
Right around 10 minutes or a couple minutes more, and we're going to open up this Q&A to you all. If you raise hands, I'll point to you, and it might help if you stand and address Timon Cline with your question. Pastor Doug.
How do you fit Dobbs into this narrative of judicial decline?
Yes, yeah.
How does that fit?
Yeah, that's an interesting question. I mean, I do think Dobbs is sort of Alito coming into his own after Scalia is gone. It's obviously a win in a sense. His history, text, tradition analysis is very good insofar as that goes. It's an expert treatment of that. His massive footnotes and all these things. So he accomplishes that. The just thing to do, though, if we had a more nimble and aggressive judiciary in the classical tradition, would just be to ban it. It's unjust and it's wrong. You can't have it. You can't murder babies, period. Of course, there were many amicus briefs submitted saying, well, that you need a textual hook, and so that would be the 14th Amendment. I'm not really interested in the textual hook. You can understand what morality is apart from the textual hook, and that's expected to be background knowledge that the judge approaches any sort of case or controversy with. So I would say it's a meager win, and now we've kicked it back to the states, and the extent to which that maneuver is actually going to be effective unto the ends that I would readily admit that I'm sure Alito and Justice Scalia, when he was alive, would agree with us on the moral principle. They're simply unwilling to let it enter into their jurisprudence. Justice Scalia, of course, believed in natural law and would talk about it, but he was simply unwilling on most occasions to let it sometimes would creep in, but to let it govern his approach to law, to these cases, because of the limitations he self-imposed, because of his understanding of the role of the judge. Very principled and honorable in that way, but ultimately detrimental to the country to approach it that way. So I would say Dobbs is a meager win, and I question the extent to which long-term it's actually a win.
Thank you, Mr. Cline, for speaking with us. My question is about your position regarding whether or not we are a government of laws or government of men. Because it seems like when you're advocating that judges should be cognizant of external standards of morality that exist apart from the text of the law, how does that provide any safeguard against a loose cannon judge who has a different interpretation of morality and does what he wants with the law, and another judge who has a different interpretation of morality and does what he wants and kind of destroys the continuity of the justice system apart from any textual commitment?
Yeah, so this phrase, kind of like self-governance that's batted around, government of laws, not men. If you look, if we want to be textualist, originalist, but no, if you want to know what it really means, you can look at the extant documents. Adams's thoughts on government, which is referring to Harrington's Commonwealth of Oceania for this very idea. Government of laws and not men is the shorthand, or by definition, what a republic is. To be a republic has less to do with the form, the government form, because that can be divvied up innumerable ways. It has more to do with what we might say the mood or approach. And so it's essentially republicanism stands for non-arbitrary governance. So there's many ways you can arrive at non-arbitrary governance. One of those would be to ground your laws in a higher law and true reason and true authority, of course, right? And so if all of your laws are suitable to or fitting with the classical definition of law we've already laid out, which is it's for the good of the community, it's promulgated, so there's notice, it's given by one who has authority to do so, that's non-arbitrary governance, right? Doesn't necessarily require, so the obsession with the textual referent, this is blamed on Protestants, but again, Catholics introduced this thing, as if sola scriptura in this sort of caricatured form leads right to this understanding of the text, which it didn't. So you can govern in a non-arbitrary way, which means you govern for the true good of the people, and that is a government of laws. It doesn't mean that it has to be written down or there has to be a textual referent in order for the judge to exercise proper discretion and determination, which we'll return to those concepts later, in adjudicating and in applying the law. That's just by nature what judges do. So it's something that evangelicals in particular, you see this on Twitter all the time, need to get over is their fear of power and these sorts of things of, well, what if we lose? Someone might do something bad to us or abuse it. Yeah, that's just the nature of the beast. So you can get on with life and govern for the good of the people according to true morality, or you can sit around and waste all your energy trying to figure out how to limit it so that no one can govern at all. And as I've already laid out, it just means you lose because progressives figure out how to do it anyway. So that's my meandering answer to that concept. Okay.
I'm curious how you reflect on our architecture of separation of powers and differentiating between legislative and judicial functions. So suppose that we have a legislature that adopts a law that you don't like. Should the judge then just simply write the bad law, or should the judge just simply promulgate or have his finding based on what the law is? What the law is rather than what the law should be.
Right, so this is actually something that in the second or third lecture I'd have to look at, highlight it out, we'll return to. So in general, under a classical conception of judicial action, in most cases, it's very simple and appropriate to defer to statutory text. It's not that there's no place for this idea of a textualism, meaning what do the words mean, let's apply them properly, so on and so forth. So in most cases, we're talking really in all this about the hard cases, right? About the things that, hence the types of cases we're mentioning, these sort of morally loaded and society-altering cases. What do you do when you come to these situations? And my contention is that it is within the judge's power to determine whether something is ultimately and actually lawful or not. But that requires a referent not. It's circular to just refer back to the text as this sum total of law. Something prior to it and behind it has to help you evaluate whether it's just or not. Now, I'm fairly agnostic about the particular way we organize or distribute labor or power in. This makes me sound like a Marxist when I say that. Within a government, it can be organized many different ways. I think our general organization is a good one. I'm fine with it. So you can work within that and respect it. But I think that something we'll get into is the record of case law for the first 100 years or so of the American Republic demonstrates exactly the type of judicial action that I am talking about. And they were very comfortable doing so. And didn't see it out of bounds, and there were no challenges to their authority in so doing for the most part. So it's simply it's not to deny separation of powers. It's not to say that have massive judicial activism where they can do whatever they want. In general, there should be a sort of deference, but there has to be, as by nature of judging and determining what the law is, both textually and ultimately, judges have to have the leeway to do this. Someone has to do it at some point.
We have time for one more brief question, one more brief answer. Okay? We'll go here.
So if we consider originalism as a sort of lesser good than pursuing new laws that are more in line with our Christian beliefs from a classical perspective, do you think that originalism can never be used as a lesser good towards the ends that we're seeking, or do you think that we should discard it altogether? And if so, how would you go about that?
Yeah, as I said, there's a sort of place for these approaches that have been Federalist Society lawyers have been catechized in for decades now. There's a place for them, they're just incomplete. And so in the majority of cases, they're probably perfectly sufficient. But when you come to no one actually cares about the entire Supreme Court docket. Like no one has any idea what's going on in it. It's just the big ones that you notice. When it comes to those, it's proven itself to be completely incapable of administering what I would say is justice. So in that regard, yes, we need to recognize its limitations, and we need to, in that sense, discard our sort of fealty to it at all times, because it's become synonymous for being a constitutionalist. It's become synonymous for being a conservative, maybe even for being a Christian. I'm not sure. And this is inappropriate. So it is at best, it was a prudential move at the time, and I think it has use. And ultimately, the text does matter, of course, but we can't be chained to it such that we're willing to sell the country down the river because we got to stand on the principle that we need to understand how the commas and semicolons work. So.
Very good. Timon Cline, thank you for being here. Would you thank him one more time?